Well, just a little bit about myself. I have been doing estate planning and special needs planning. Really started beginning my practice for the last 20 years. It is a narrow niche. Not a lot of planners do special needs because it's very technical. It's difficult to get a plan to work right and interlace with an individual who has benefits that are coming from the government program. So, but there are a few of us in town. Why plan? This is a It's important to consider in advance the type of plan that you may need for your family member who may suffer from a disability, because in order to ensure that they have the best opportunities in life, we got to make sure that there's something in place. So when you're not here to take care of them, there's a plan that's going to be implemented to make sure that happens. So some of the benefits of planning will provide financial security. Utilize means-tested public benefits. We'll talk a little bit more what that really means. You may have a team that has to replace you. You're kind of a team in a lot of respects because you the one taking care of so many aspects of this individual's life. But when you're gone, it may be a team. I'm impressed just by the number of resources that we've heard from just tonight. The community has a plethora of resources. Plan for appropriate housing, provide ongoing assistance for advocacy, caregiver needs, coordinate entire extended families planning, protect beneficiaries from predators. Unfortunately, there are those out there, and it does happen. Preserve assets for other heirs. This doesn't just happen, it has to come in the context of a plan. So the first thing we'll talk about is create an effective estate plan for your loved one. And the question comes, what can you do right now that might benefit your loved one that has special needs? And I would suggest one of the things you could do today is create a memorandum of intent. Well, what's a memorandum of intent? Well, you might have a great estate plan in place, but there's nuances of the type of care that your loved one receives that only you might really know about. What are all the different benefits that this individual is receiving? What are the different caregivers that are involved? Who is involved in that individual's life that you would want to stay involved in their lives when you're gone? Make sure they're able to have access. What are the special preferences and needs? There are certain things that may have taken you years to discover, and you won't want someone else who's now providing care to have to learn these things and take another 10 or 15 years. It might be discovered when my child is really upset. If I brush their hair, they will calm down, and we'll just do that for 5 or 10 minutes, and they will gather themselves together. Well, wouldn't that be something important for your caregiver to know? Well, how are they going to know that unless that's done in writing? Because if you're not there to explain that, and that's really the idea of the memorandum of intent. And that's something I think every family should have as part of their estate plan. So another thing you can do is consider what the cost might be. There's a little calculation here, right? If you look ahead and kind of project what would be the sources of income to support your child's needs, what would be the expected expenses for your child, and do a little analysis, a little cash flow analysis, and see what's this going to take and how you're going to fund it. I see a lot of families that will use, particularly younger families, that maybe haven't accumulated their own estates yet, use term life insurance. If they have good health, it can be rather affordable, and it's a way to fund a special needs trust or estate plan for a loved one without a big expense up front. So I just put a little ledger here, or spreadsheet, that kind of gives you an idea of what I mean when you walk through, and let's see what that might look like in terms of expenses and what do we have to plan for. An integral part of any plan for an individual with special needs generally involves a special needs trust. What is a special needs trust? Well, a trust is really a way to ensure that benefits can be protected and available for your loved one, and help them maintain eligibility for a means-tested benefit, a benefit from the government program. It's called a third-party special needs trust because it's not funded with the assets of the individual that has a disability. It's funded from another source. Maybe it's a parent or grandparent or some other source, but it's not the individual. And that's a very important distinction. We're going to talk about a first-party special needs trust in just a minute. I'll get more into third-party special needs trust here in a few minutes, but I'm going to introduce this concept. So another thing that you can consider is, does your loved one with special needs have sufficient mental capacity to execute their own legal documents? Because if they do, it might be very helpful to have a power of attorney. And there's a number of reasons why that comes into place. One is, if your child turns 18 and you don't have an adult guardianship put in place, well, suddenly you might have some challenges in making medical decisions for your child. You say, well, that's my child. Why can't I make decisions because they're an adult? Well, they have a disability. Yeah, but unless the court of law says that they are legally disabled and unable to make their own decisions, they are presumed to have that ability. And so medical providers can say that, well, you're going to have to get a guardianship if you want to make any decisions for your disabled child. And so that's something else you need to think about is, are we going to need to plan for guardianship? Or can we use a power of attorney to help with medical or even financial decisions if there's accounts involved for saving? Another thing to consider, and I see a lot of families do this, is if they do have adult guardianship in place, what happens if you're unable to continue to serve as the guardian for the protected person? And what they'll do is they'll have someone appointed with them as a co-guardian. And they won't necessarily have any functions or need to serve, but they're standing in the wings, so if something happens to the guardian, they're unable to serve any longer. There isn't this delay to go back to court, petition the court, get someone else appointed, and now we've got a little issue because we have somebody without an adult with authority to make any decisions on their behalf. And so that's one way you can deal with guardianship in the case that there's somebody there that can't serve any longer. I'm going to talk about first-party special needs trust. So it could be that you have a very well-meaning grandparent that says, I know I have a child with a disability. Maybe they won't be able to support themselves for life. So I'm going to leave them some of my estate when I die. So in their estate plan, it says, to Johnny, my grandson who has a disability, I leave this asset. Well, if they're receiving a means-tested public benefit, one that is based on financial need, and grandparents just left this asset, maybe it's an account, maybe it's a home, funds of some sort, now they're disqualified. And they no longer have the medical care through Medicaid, no longer have the SSI. That wasn't much of a gift, because now it just has to get spent down. We have to go through a reapplication process, or at least try to get reinstated. And it's not very helpful in the end. So what do you do if that happens? Because it frequently does, where the funds are left, there are some assets left to a child with special needs who is receiving a means-tested government benefit. Well, that's where the first-party special needs trust comes in. And the way this trust functions, it's first-party because that individual with a disability owns the asset, because they've been listed as the beneficiary, so it's theirs. Let's just say it's an account, pay on death, or maybe it's a UTMA account, or a 529 plan, or something that's funds for them. and we've got a little eligibility problem now. So either the individual, if they have the capacity, a parent or a grandparent or a court of law, can assist in establishing this first party special needs trust, and these funds then would be transferred into that special needs trust. The benefit is they maintain eligibility for the benefit. And yet they have this fund here that they can be accessed from the benefit to supplement their care. Now, we're going to talk about the rules. It's very careful. You have to be very careful how you use those funds of the first party special needs trust. It's the same as a third party. We're going to get to third party in a minute. But it's possible to establish this, have the funds put in there, and now they get the best of both worlds. The drawback with the first party is that upon the individual's death, that's their first party trust, the funds will go back to Medicaid. In other words, Medicaid has the right of recovery against the estate. They will keep a tab for everything they've provided in terms of care for the disabled individual, and the trust must have a provision that says Medicaid gets the first bite at the apple at the death of the special needs beneficiary. Okay? So it has a payback provision. And third-party special needs trusts do not. So if grandma and grandpa instead have their living trust, and the living trust says, not to Johnny, to this special needs trust for Johnny, that's a third-party trust. It never gets to Johnny. It gets to this other trust. He's just a beneficiary. It's not his. He still has to disclose it, but there's no benefit issues. You're not going to jeopardize it. And the best thing is, if Johnny deceases, the grandma and grandpa can decide where they want to go. They can direct it to go to the other grandchildren or to an agency or whatever. They can decide it's not going to Medicaid because it was never Johnny's asset. So that's what's very important about these third-party trusts. We really don't want to see funds going directly to an individual who has benefits through a needs testing program because it's a problem. It's not available if you're over 65. You can't, if you receive funds from a parent, you're over 65 and you're receiving Medicaid, there's going to be some issues. There are some other workarounds, not quite as effective, but there are workarounds that we can implement to still try to preserve the benefits. So let's talk a little bit about some of the benefit rules. I think it'll catch up in a minute here. I'm not a public benefit rule expert. In fact, the best public benefit experts I've seen are parents that are living it because they're in the trenches, they're working with these rules every day. It's not really a legal thing, it's a regulatory thing. You just have to understand the regulations. But you have to have a certain basic understanding in order to navigate this, and so that's what we're going to go today. I keep saying means tested public benefits. What is that? Well, we're talking about supplemental security insurance. This means tested means that you have to qualify for it. It's not an automatic. Entitlement public benefits is automatic. Okay, you've contributed enough into the system where you will qualify for SSDI and Medicare if there's a disability. And there's other programs. Section 8 veteran benefits are two of them. So in order to qualify for SSI, which maximum benefit this year is $841 per month for SSI. You have to meet two tests. One is being medically disabled and be impoverished. And the income test is really, or the financial test is really two prongs to it, and there's a resource test and an income test. So the resource test is measured once a month, and that's where they determine, and usually it's the beginning of the month, do you have over the resource limit? And the resource limit is $2,000 a month. You can't have more than $2,000 in an account. If there's more than that, you roll into the first of the month, you're disqualified. Now, if you have more than that during the month, you're okay, because those funds can be utilized for expenses, for exempt assets. And then there's income. And income's test is any time of the month. So let's look and see how this works. The federal benefit rate is $841 a month. If you are a couple, it's $1,261. Some states have a supplement to that. So in California, in addition to the $841, you would also qualify or may qualify for 524. That doesn't have that. And the amount can change depending on some other factors. Disability is defined for an adult as the inability to engage in any substantial gainful activity, SGA, due to any medically determinable physical or mental impairment or combination of impairments that has lasted or can be expected to last for a continuous period of 12 months or more, or resulting in death. This definition can be met at any point in someone's life and be qualified. So countable resource limits, $2,000 a month. If your couple is $3,000. So if you have two disabled individuals who are married, this is what some consider a penalty. Sometimes you see disabled couples live together but not married. That's why. Because they can have $2,000 each, so have up to $4,000 versus $3,000 but not, and their benefits are higher too. But you saw it was $1,261 for a couple versus $841 times 2, so they could be over $1,600 or not. Not all resources are counted; some are exempt. This is one of the things that we try to do if somebody does have too much to qualify, or they receive some kind of benefit during the month that's going to put them over, then we do a little spend down, try to figure out where can we put this asset that's too much in an exempt type of asset. A home is exempt, a car is exempt, a prepaid burial plan, Medicaid qualifying, is exempt. Household items, tangible personal property inside the home is exempt. So sometimes we'll just prepay the dental bill. We know it's going to be $4,000 worth of dental work needs to be done, let's prepay that. And we're okay. We're on to next month, and long term, $2,000. So what's another way we can spend down and remain eligible for benefits? All right, so there's 4 types of income. There's earned income, unearned income, in-kind, and then deemed income. Don't think of income as the type of income you might see defined with IRS. These rules do not speak to each other. When I'm talking about these benefit rules, we're talking about Social Security Administration, not IRS. They're completely different, okay? Different areas of the law, and the two do not coordinate very well. So let's look at income. By the way, you can ask questions at any point if you want. Feel free to raise your hand. So if you have earned income, the first $20 is exempt, and the first $65 for earned income in a month is also excluded. So then you may earn income, but every $2 you earn, $1 is going to offset your benefit. So if your benefit's $841, and you earn $41 during the month, then you're going to lose half of that amount you earn. I got a little example here. So let's say you earn $585. Your SSI check's going to be reduced by $250. Why? Because if you start at $585, but you have an $85 exemption, that's the 20 plus the 65. Then that's 500 less half of that, 250. You can see how somebody could still be net ahead if they had a job, but there's a point where you lose the benefit. So you could, if you hit the sweet spot, earn some. It's probably a little discouraging because for every dollar you earn, 50 cents goes out of your benefit, but you're still net ahead. I don't know, I guess that's supposed to be an incentive, but it doesn't seem very incentivizing to me. Unearned income. And this one's tougher, right? So this one comes from other sources that weren't earned, like a gift, and the problem is that one's dollar for dollar reduction after your first $20 exemption amount. So if a child receives $585, take out the first $20, $565 is how much is coming out of their $841. And that's assuming they qualify the full amount for the $841. If they qualify for something under $565, let's say they qualified for $500 a month, and they lost and they had income of $585, the reduction is going to put them below what they're already receiving. So now they lose the benefit for that month. So it really is probably going to happen the following month, and then they'll get reinstated the month after that. You got to really watch that. In-kind support and maintenance is when a beneficiary from one of these programs is receiving, I'm really talking about SSI, is receiving a benefit other than earned and unearned income. So we're talking about like free lodging or food, or even if it's reduced but it's below market value, would be reasonable. Like you say, well, we're going to charge you $100 to live in our home. Okay, well that's really income, in-kind support maintenance. Depending on the SSI recipient's living arrangements, the SSI check reduction is subject to either the value of the gift, so SSI is going to look at that and say, well, what is the market value of living in somebody's home? If you were to rent that home, you have certain common areas, the kitchen and the bathroom, what would you charge somebody to do that? And so they're going to look at that and say, okay, well, that's in-kind support, maintenance. And so this is the market value, going to reduce it. If it's a minimal amount, you probably just have them reduce it by that market value. But there's another rule here, that's really an interesting one, where the caseworker could actually reduce it just by 1/3. And here's how it works. It's kind of complicated. And so I'm just going to brush on it. So it's presumed if you receive $841 the full amount for the month. And if you reduce $841 by 1/3, then that's how much they'll reduce it down. But if so 1/3 of $841, where that puts it 5 something. If you have that amount coming in, then you're fine. And you can actually get, and some families will do this and they'll pay for everything. It doesn't matter. You can spend thousands of dollars on them a month and just get the 1/3 reduction, and you're okay. But you have to be careful, because if they're getting less than that, now they're disqualified. Okay, so you kind of have to run the numbers on it. You really only have to have $1 left to get the SSI to still remain qualified for Medicaid in Nevada. A little complicated rule, and you're probably not living with that unless you have an adult child who's receiving benefits over 18. All right, deeming. So deeming is when a person is legally entitled to support from someone else, like a parent or a spouse. Okay, and if that individual has income coming in, then that income can be deemed to that special needs individual. So that's why you don't often see children that are under 18 receiving these benefits, because if the parents are working, then their income is being deemed, and you can't qualify. It's difficult to do. But when they turn 18, now you're just looking at their qualification, because they're not an adult. Okay, so SSDI, if you're disabled before age 22, and with parents that are eligible based on their work record, basically you're entitled to SSDI if you have worked 10 years full-time. They count work quarters. It's called work quarters, and there's a formula. But basically it's 10 years full-time. And if you've contributed 10 years full-time with your FICA or your paycheck, and then you become disabled, you will be eligible for SSDI, hopefully, okay, and eventually Medicare. It may be that you could be eligible for both SSDI and SSI, but your Social Security benefits could eliminate your qualification for SSI. Medicaid covers medically necessary services, preventive care, long-term care in nursing homes, or skilled nursing facilities. Medicare is medical coverage. Hospital stays, prescriptions, not long-term care or preventive care. Okay. If you qualify for SSI in Nevada, you will automatically qualify for Nevada Medicaid. Right? You do have to apply separately for SSDI. Nevada does participate in expanded Medicaid, so in other words, if your income is below 138% of the federal poverty level, then you will probably qualify for Medicaid. So anything up to 138% of the federal poverty level. I looked at those numbers. It's like $17,000 for an individual and $32,000 for a couple, something like that. Medicare, you will qualify for it after 2 years of SSDI. All right, so let's talk about special needs trust planning. So we've already kind of brushed on the fact that a special needs trust is there to preserve assets for an individual so that when you're gone and that trust gets funded, assets are there to provide for the care. Sometimes I'll have clients who will draft a standalone third-party trust. What do I mean by that? You can have a special needs trust embedded in your own revocable living trust. So in your revocable living trust, it says, upon my death, I want this share to go to Johnny, my child who has special needs. Or you could say, I have this special needs trust over here, and my own revocable living trust over here. And I'm going to put funds in this one for my child. Or better yet, I might have family members who say, I don't have those fancy trusts. I just have a will, or maybe I have some pay on death designations on my bank accounts, but I want to leave Johnny something. Okay, I've got a trust I put in place. It's already there. And so you just list the name of that trust in your estate plan, and when you're gone, it's going to go automatically into that standalone third-party trust. See how it works? Versus you have this third-party trust inside your revocable living trust, and it's not going to be funded until your death. And once you're deceased and your assets are liquidated and it funds that, that's when that comes into being. That's why some people want this standalone trust, because they might have a family member or some parent, somebody who says, well, I'd really like to leave something to your child. Don't leave it to them directly. You're going to cause benefit problems. I've got a special needs trust over here for them. Name that in your estate plan or in your will or whatever, and we'll be fine. Well, that's why sometimes we have these standalone special needs trusts. You can appoint a management team through your estate plan, through your third-party trust. So you might have a social worker in there, you might have a nurse in there, you might have a trusted family member in there. You might have a little team you put together. It could be advisory level, it could be the actual trustees who are managing funds, it could just be making care decisions. There's a lot of flexibility on what that might look like. All right, so we already said that outright inheritance is not a good idea because you're going to jeopardize your eligibility for benefits. You don't want to just leave it in a revocable living trust. You say, well, I've got a revocable living trust, or I know my grandparent has a living trust. Isn't that good enough? No. It has to be a special needs trust. And it can't just be a special needs trust. It has to be a qualifying one. I can tell you how many I review that they don't work. So what happens when you have a special needs trust and it's funded? They all get sent to the Attorney General's office, the Nevada Attorney General's office. And there's an attorney that reviews them. And they will get kicked back if they don't meet their criteria. And so you have to be really careful how these are drafted, because if it's drafted inappropriately and funded, you might have special needs trust and still have an eligibility problem. Fortunately, the rules have relaxed a little bit. We don't have to run to court to get an irrevocable trust, because usually special needs trusts are irrevocable by the time they're funded. To get an order to fix it, now they will give us, we can put in provisions that allow us, the drafters, to fix it. It's called the trust protector, and we can go in there and fix the offensive language and make the Attorney General happy. Sometimes they say, oh, well, we just won't leave anything directly to our special needs child. Instead, we're going to leave it to their brother or sister or another trusted person. They'll take care of them. They love them. They've been with them all their life. They will take care of them no matter what. Yeah, but what happens if they get in an auto accident and get sued? What happens if they get divorced from their spouse? And you've got funds. Oh, yeah, it's for John. It doesn't matter. Their name's on it. It's part of the divorce estate. It's going to get split with the divorcing spouse. If you're not careful, they can't choose their creditors. Usually it just happens. There's an accident or they owe. So it's not a good plan. What if that individual develops their own disability? What if they become incapacitated? So, or they deceased and the assets are part of their estate. How do we assure? So I don't recommend that. A lot of families will do that. They'll say, I'm just going to leave it to their sibling. The sibling will take care of them. I know they will. That's not what I'm worried about. I'm worried about their creditors. And what happens when they're gone? Then what happens to Johnny? All right, so some of you may not be very familiar with what a trust really means. So let me just kind of step back for hit some basics for a minute. A trust is a way to hold assets in, think of a box. And your name's not on it directly as an individual. It's on it as a trustee. Okay? Trustee is the one that manages it. So, for instance, let's say I own my home. Well, the bank owns it, but I'm living in it until it's paid off. And I developed this trust. So now the deed's going to read my name, comma, trustee of my living trust. Or maybe I have some accounts. Okay, my name, comma, trustee of my living trust is on the account. Or on the life insurance. Or on the cars. On most all the assets, probably not retirement, unless you have a special needs child. If you have a special needs child, you put their name right on the retirement, big problem. Yeah, but I don't want to put their name, I don't want to put the trust on retirement because if I do that, it's going to pay out directly and we won't get this stretch for the IRA. It's a 10-year stretch. You would rather lose their benefits versus the 10-year stretch, and it's not worth it. There is we talked a little bit about Trust Advisory Committee, which we can incorporate into your living trust. And then finally, Trust Protector. So it's a really convenient provision we can do in Nevada where you have an individual, could be a team again, which can be there to assist if there's a problem. Most of these special needs trusts become irrevocable when the trustor is deceased. Trustor is the one who created it, right? So mom or dad. And they're gone. And so this trust gets funded for the child with disability, but we've got a problem. The rules changed. It was written under the rules under 2022. Fast forward to when mom or dad are deceased and it gets funded, and now the rules are different. What do? Mom and dad aren't there to change it. And these trusts generally are irrevocable. That's what a trust protector can do. And they can be given some authority to go in there and make some modifications to an irrevocable trust. Very handy feature to have.
Who can be a trust protector?
Usually it's a professional that drafted it. Usually it's an attorney.
Okay, so you have
it can't be the trustor, the person who drafted it. Usually it's not implemented until they're gone anyways. Usually the attorney, because they're the one that probably need to go in there and make a modification for the rule change. But it could be somebody else if they're qualified to modify a trust. Revocable versus non-revocable. Well, you can't ever have a beneficiary as a trustee of their own trust. You can't do that with special needs. But can the trust be revocable? It can be. If it's a trust that you establish, this third-party trust I talked about, and it's standalone, well, you may want it to be revocable, but you may want to change it if the rules change. If it's part of your living trust, it's going to be revocable because you may want changes on your living trust. As circumstances change in your family or the laws change, you're going to be making changes in your living trust, which has your special needs trust inside of it. But once the trustor's died, the one who created it or established it, once they're gone, well, it becomes irrevocable. There's anybody else left to change it. It's your trust. Do you want somebody to come in afterwards and change it? With different beneficiaries in there? Usually not. It becomes irrevocable after the death of trustors. A living special needs trust lets other family members and friends contribute. We've talked a little bit about this standalone trust, and I think that's really a good solution if somebody wants to do that while you're alive. Distribution standard means that when distribution happens out of a special needs trust, it's got to be drafted in a very specific way. It can allow the trustee to make distributions directly to the special needs beneficiary. Why? Because it's income. If the trustee, doesn't matter if they can do it or if they actually do it. It just matters if the language is there. If they have the authority through the trust to do that, Attorney General will say, go back to go. You don't pass, start all over. Because you can't have a trust that authorizes, whether they use it or not, it's not the point. They can't authorize them to give money directly to the individual. That's income. They have to report it. So how do you do it? Well, you have to authorize the trustee to make purchases to vendors or for services for the benefit of the individual. See the difference? And so they could say, yeah, we'll buy you a car. You go to the car lot, you pick one out, it seems reasonable, appropriate, and we'll buy it for you. You tell us who the person who will get caught, we'll write the check. But we're not giving you the money to go do that because that's income to you. Even though you're buying something that could convert into a exempt resource. Because when you give it to them, that unless you do it all in the same month, you might be okay. But generally, you can't give it to them directly. So distribution standard, and you can't give it. You can't use it for certain things like housing. You can't give them money for housing. What do we use it for? You can't use it for housing. That's the biggest expense. You use it for medical. And there's a lot of things that Medicaid is not going to cover. It's not going to cover dental. It's not going to cover the specialist in San Francisco. They need to go see Mr. Davis. It's not going to cover optical. So there's things that a special needs trustee can pay for. They can do things like entertainment. They can do things like educational things, but not housing and not food. And when it gets to housing, there are certain utilities. You can pay for phone, but you can't pay for gas or electricity. I mean, it gets very, very specific. And so these rules all have to be, we put them right in the trust. So that's the distribution standard. By the way, if they go on vacation, you're paying for vacation, you better not pay for the food. Right, they're out. It's a restaurant, doesn't matter, it's food. You see? I mean, it gets really technical on these trusts. And so you have to be really careful how you draft it. Otherwise, the trustee, oh no, I'm over 2 minutes. The trustee can get in trouble.
So I have a question. You said earlier about how low they're fixing that. Housing, back to your earlier slide, doesn't count as income. If they own a house, that doesn't count as income.
A house is an exempt resource.
But you said they can't use their trust for housing, so you can't pay them. They can't pay
To
them
pay for housing. So they can't pay a mortgage. But the house can be owned by the trust though,
But
and
they
they can
can't
live
pay-
inside the house that
But
the
they
trust
can't
owns.
pay the mortgage on
No,
it.
so if the house is in their name, that's okay. But if there's a mortgage for the house and the trust is paying the mortgage, you might have a problem.
Okay.
Or paying the rent, you might have a problem. It's just oh, she stepped out.
It's kind of the same thing. We've got our house going to both of our sons. One has special needs, and I think it may have to be updated to trust. They couldn't put anything towards the house, like property tax, insurance, upkeep, utilities.
Okay, well, in that case, it's not going to a renter, someone who owns the house, the trust owns it. So the trust is maintaining its own asset. The trust can pay utilities on that asset. That's okay. That's a little different.
Okay.
Then if
So
you say-
if it's half his though, and half his brother's, so if
That
the
still shouldn't be a
part of
problem.
the trust could still pay.
Yeah, no,
So
that's
the trust can pay for the maintenance of the, trust can pay the mortgage because it's the maintenance of the house that the trust owns.
yes. But the distinction would be if that individual is living in somebody else's house
Right.
and the trust is paying rent.
No, I'm talking about.
That's where the problem comes from.
Okay.
See the difference? All right, so there is one more type of special needs trust that I want to talk about, and it's a pooled trust. There's actually two types of pool trusts. There's a first party pool trust and a third party pool trust. What's a pool trust? Well, that's where you have one special needs trust. It's a master trust. And it may have a lot of special needs beneficiaries that participate in that trust. So in other words, the funds go to the trustee of this pool trust, and then that trustee administers it for a special needs beneficiary, but they may have 1,000 others that are in that same trust, okay, that governing document, and that's okay. There are national ones, there are regional ones. There are ones just for like recoveries in cases that are PI cases, personal injury cases, and there's been a recovery because of an injury caused a disability. So there's all kinds of these pool trusts. Usually they're non-for-profit. One of the things to know is sometimes these pool trusts will say that if the individual deceases, there's something left in that trust, then that goes to them, or a portion of it goes to them. I kind of want to watch these. Nevada does recognize pool trusts. There is a company here in Nevada that says they do this. I'll be honest with you, I've never used one. It's a little tough to make them work, but they can work. Here's where I see them work. If, I don't have a first party here, but let me explain it. So first part is, this would be if the individual receives funds and you say, yeah, but they're only getting a modest amount. Let's say it's $100,000. Let's say it's $30,000. There's some bonds. Grandpa left some bonds, three $10,000 bonds to Johnny. It's a problem in his name. Okay, we can create a special needs trust. Yeah, but we're going to use thousands of dollars to establish a special needs trust. It's hardly seems worth it because we're going to spend so much to establish the trust. Is there another alternative? Yeah, you can do a first party pool trust. Doesn't cost you. Now they have some administration costs, but it is a way to get the money moved over without having to establish a special needs trust for them. And so it works when the amounts are really modest. We don't do those very much. Okay, trustee responsibilities. So a trustee invests the assets, distributes the assets, keeps records, takes care of the taxes, files returns. Hiring advocates, care managers. They do have personal liability. A trustee has some skin in the game because if they don't file taxes right, IRS can come after them personally, potentially. If they invest the funds and the investments don't go too well, there's a correction in the market, and the values start going down, they could be held liable for that. So you want to get the right person in there who's going to do the right job. All right, let's talk about ABLE for a minute. ABLE is really been a huge benefit for families with special needs. Let's face it, $841 a month doesn't get you very far. And if that's a source of income through SSI, I mean, our families come in and they'll tell me, oh, we supplement that. You do what? Well, we give them cash. How do you do that? Well, we've just been given to them. Do you disclose it to Social Security? No, you're supposed to, right? Yeah, we don't tell them. That's how they do it. Well, you can't do that. Sorry, I can't. You can't do that. I can't tell you that's okay because it's not. Well, is there a way to give them cash because they can't make it $840? How do you get rent for a place for $841? It's considered. That's why you can't use it for housing or food because it's considered to be enough to pay for housing and food. I had somebody in my office just the other day, and she said, she was getting Social Security and it was under $2,000, but she said I can't even rent a place for that. All right, so how do you do it? So ABLE is a really good tool that we now have, and here's how it works. The disabled individual or the legal representative, if they're minor, it's the parent. If they're adult over 18, then it's under that power of attorney we talked about. That's why the power of attorney might be convenient. But if they're unable to get a power of attorney, then you might have to get a guardianship, adult guardianship. And they establish the ABLE account. How do you do that? You go to nvable.gov on the internet, you pull it up, and in about 5 minutes you can establish this ABLE account. Okay? State of Nevada works through this third party, it's an internet bank, and you're gonna get this little card in the mail and you've got your Able account. I mean, it's really that easy, okay? So what do you do with a bank card? Well, you wanna fund the account. You can fund it up to $16,000 a year. That number should sound a little familiar if any of you have funded college savings plans, 529 plans. So here's where Able started from. So for many years we had 529, and the goal was to be able to put funds into the 529, and you can use those funds for qualified educational expenses, and the income in there, you don't have to pay income tax on if it's used for tuition or books and things like that, right? And so parents will put money away in the 529s for the children to go to college. But what about the community of disabled individuals? We had no corollary, no tax incentive to build any kind of fund for them because they're not college bound. So I think Congress finally realized there's an inequity here. How do we fix it? 529A. This is not a Social Security rule. This is an IRS rule. It's a tax rule. It comes in the code. When this first got passed, we held our breath for about a year because we were waiting for Social Security to see if they're going to honor this little exception that IRS created. Remember I said they're two separate rules, two separate programs, and they don't coordinate very well. So finally we did get a real change and to the POMS, Program Operation Manual for Social Security. That's so if you want to know the rules for yourself, you look up the POMS for Social Security Administration, and you can find whatever you want to know about how these rules work. By the way, Social Security Administration website has really good Q&A, and it'll walk you through these rules in a very plain English way. So, I need Jessica's fingerprint. So this plan then will allow a parent to contribute up to $16,000 into this 529A account, or an Able account, Access for a Better Life Act. And the funds in there aren't going to be used for qualified educational expenses. They can be used for housing. They can be used for food and just about anything else. So that's why it's so handy, because you can't take funds from the Special Needs Trust and pay directly for housing and food without creating a problem. But you can take $16,000 per year and put it in this Able account, and then that special needs beneficiary can access the Able account with their little card and pay their rent, go to Walmart and pay for food, and there's no problem. So $16,000 is not a lot, but it can be when you're living on benefits. That can go a long ways. I mean, it's over $1,000 a month to help pay towards rent or food. So this has been a really helpful tool. Is this Able? You establish this account, the legal guardian representative can establish it, and then they can fund it up to $16,000 per year. Okay. Funds in Able account are directly in control of the individual or legal representative. Source of income is tax-free, and gifts to the account are tax-free. $16,000 per year, up to $100,000. So they can put, if they just accumulated in that account each year. So if I put $16,000 in December, and then January put another $16,000, I've already got up to $32,000. I can go all the way up to $100,000 and still maintain eligibility for Medicaid. IRS actually says you can put up to $550 in it and still have your tax break on the income in there, not have to pay income tax on it, as long as it's for a disabled individual. Problem is, Medicaid has the right to recovery against the funds in there. Meaning that, let's say you put $100,000 in there over a course of several years, and you go, well, that's a place I can tuck it in and I can use it for anything. Yeah, but if they deceased, if your special needs level on deceases and there's $100,000 left in there, Medicaid gets paid off first. So if there's been a lot of benefits and the big bills accumulated over the years, money out goes away. So it's not perfect. What most families will do is just fund enough each month to cover expenses. Or maybe they do it annually, but they just don't let it get over a certain minimum amount. They don't want to fund up to 100,000. You might lose it if there was a death. It won't disqualify you from other benefits that you have in there. All right. Does anybody here have an ABLE account or set one up first? How's it working? Is it effective? Are you? But families who didn't have, who were part of the system for benefits, who now had ABLE suddenly, I actually started about 8 years ago, I just feel like this is an amazing thing because before we had a huge gap and we just had a way to fill it. This is a way to do it. All right, so I made a little comparison on a little chart here, and that's what this is. Let me see if I can slide view. And so what this does is it compares the different types of tools available. Now this one compares ABLE accounts and third-party special needs trust. And I'd say generally speaking, both will go together. You usually have a special needs trust, we usually have an ABLE account too. But it might be you just have an ABLE account because there's not a lot of funds we have to really deal with. Maybe the individual is able to manage their own funds in that account. But, I didn't update that, it's 16,000. So,
so it's the same as the annual gift.
Yep.
Okay, so it goes up.
Because it's 529, it's the same tax provision.
Okay.
It's just 529A instead of 529. Yeah, it goes up periodically. And then I did another chart here for ABLE and the first party, it's called D4A, that's the code section. A pooled special needs trust and a third party and an ABLE. And you can kind of compare the different ones. So I think that might be handy if you want that. I printed those slides off. I also did a little memo here. This is actually it's created for a trifold, but I didn't print it off as a trifold. I just printed it off. But this talks a little bit about establishing your memorandum of intent. We talked about that at the beginning. And it gives you some pointers on how to get that memorandum of intent in place. I think that's something you can do right now, and I think every family should have one of those. So that might be helpful. So I need that up front. I think that's about all I have.